Hey, good evening, everyone. This is State Representative Brad Halbrook with a special Friday night live stream edition with breaking news out of Effingham County. And with that, I'm going to introduce the chairman of the Illinois Freedom Caucus, Chris Miller, with a quick welcome, and then we'll go to whoever else is joining us here tonight. Chris Miller.
Hey, it's great to be here with all you patriots this evening, man. What a great country we live in. You know, that's one of the reasons why we live in a constitutional representative republic, is so we aren't ruled by the whims of tyrants in high places. But I want to thank you guys for stepping up the plate and advocating for we the people. What a great victory today. Thank you very much.
Excellent. And next up, we got Dan Caucus has joined us from Decatur. Dan, we're getting started. Thanks for joining us. Are you plugging in there, or if we can come back to you for a quick welcome? Let's go to Adam. So Adam.
All right, folks, we just had this idea a little while ago. We're bringing everybody together here. I want to thank you for tuning in with us here this evening on this breaking news out of Effingham County. And I was in that court on the other day, on Wednesday, when Mr. DeVore was making the arguments. And I got to tell you guys, he made some excellent arguments. There's some issues I want to talk about on those arguments. He did an excellent job. And it's not just about, guys, the issue of the gun ban, J.B. Pritzker's unconstitutional gun ban, but he brought up other issues that we're going to get into tonight.
Okay. Dan, are you live there? You got a few opening welcome comments, maybe?
Hey, can you hear me?
Perfectly.
Oh, great. Thank you very much. Great to be on. And thanks, Scott, for joining us. And obviously, Counselor, good to have you with us again tonight. Man, my phone's lighting up. I can't imagine, Tom, I don't know how you got time for this.
Always make time for my friends.
I know, but man, oh man, oh man. This is Macon news from Chicago to Cairo, Quad Cities, all the way to Danville. We're getting messages from people. We're elated, but cautiously related, I think, and Tom will get into that. And of course, Scott was part of the Safety Act lawsuit, so he's had some experience in these TROs. So let's dive into it. I'm ready.
Yeah. Great. Thanks, guys. And so, guys, we were talking before we went live about how the General Assembly does their best work after 5 p.m. Nights and weekends and holiday weekends is when they do their best work. And the next people that enjoy the benefits of all that work are our attorneys across the state, fighting back and pushing back on this tyranny by this bunch. It seems to be we're now in the Executive Order 36, well over 1,000 days under Executive Order rule. And one of those guys that have pushed back on that from nearly day one since the tyranny began is Attorney Thomas DeVore. Welcome to the event tonight with us, Tom. What can you tell us about what happened in Effingham County this week and more respectively this afternoon about 5 o'clock?
Well, the judge in the Effingham County Court issued the restraining order that we requested on behalf of our 866 clients. And in essence, what we're arguing about there, Brad, is it's not a direct Second Amendment argument that we're making. I mean, that argument is significant and will be brought in the federal court by us as well as some other lawyers. But what we brought was the issue of the Illinois Constitution and the procedural gamesmanship that you gentlemen know far too well that's been going on for decades in the Illinois General Assembly. Even though the supermajority is held by the Democrats, they still find it necessary to engage in this gamesmanship and really circumvent the legislative process. So we made those arguments in the Effingham County Court in addition to an equal protection argument. And so the judge issued the ruling today that we can talk about in more detail and fashion that you see fit. But he agreed again, in principle, with every one of the 4 arguments that we made, finding that, in fact, the Illinois General Assembly is violating the Constitution of the state of Illinois on numerous fronts. So he entered that order where the new gun bill doesn't apply temporarily to all 866 of the clients named in that case.
Yeah, excellent. Also, we want to bring on Macon County State's Attorney with a few opening comments. Scott, you've been on with us in the past once or twice talking about the Safety Act. You've been a part of that pushback effort there with multiple state attorneys across the state. What's your thoughts on the TRO that was issued tonight?
Well, obviously, I support our individual right for possession of firearms, but we of course have a. We talk about these things. Unlike the public safety, it directly affected how we performed our job. This is a statute regarding the enforcement of a criminal offense that they tried to make certain offenses illegal. It wasn't a direct on how we performed our job, so we're kind of aloof in this one. I personally agree with the result. It's good to see that this is the result now. It's unfortunate that it's only as to the, I think, 886 or 866 defendants named, or plaintiffs, I'm sorry, named in the offense. We'll have to see where it goes from here, but I think it's a good start.
Excellent.
And when you guys got your TRO on the Safety Act, it immediately, because it really fractured the state up county by county by county. Explain why you guys got a statewide TRO in such a big hurry.
Sure, there was, as in this case, there was the argument that it was simply applied to the people that were plaintiffs in the case. I'm not so sure that quite honestly applied, because there was a finding in our case that the statute was unconstitutional. I don't think, Tom, and you correct me if I'm wrong, but the way I read the decision, there's not a finding of unconstitutionality per se here, as much as there is a finding that the TRO is in effect pursuant to the lawsuit filed. There's not been sort of a final finding that it's unconstitutional. So because we had that in our case, a final finding of unconstitutionality, we applied to the Supreme Court for a supervisory order saying that, this is going to cause great confusion, where you have some parts of the state that say that the Pretrial Fairness Act should be in effect, some that say it shouldn't. The Supreme Court said, yeah, we're going to put it all on hold until we have time to decide this issue. So for ours, it has now been applied to all counties in the state of Illinois. It's a little bit different, as I've got friends here, sorry. Applies a little bit differently in this case because it's filed by citizens of the state rather than the state's attorneys in general.
Hey, Tom, thanks for coming on here tonight, Tom. I've got a couple of questions here. Okay. I'd like to dive into the meat and potatoes of what you argued on Wednesday. And folks, this is really interesting stuff. He argued the single issue, 3 readings, due process, and equal protection with irreparable harm. Can you kind of break down your argument a little bit? And could you talk more specifically to the first 2 points and then also to the second 2 points? Because the first 2 points are very interesting as it relates to the way business is done in the General Assembly and how this could have an impact on late night bill readings, third readings, single issue headings on bills. Could you discuss both of those in 2 sections?
Yes, sir. So the Article 4, Section 8 of the Constitution says that a piece of legislation has to be confined to a single subject. So what constitutes a single subject has been, in front of the court many times. And the subject can be pretty broad. I mean, they could present a subject to the legislature that says an act concerning criminal law. And it sounds pretty broad to most people, but the courts have said that's fine. But when a bill is introduced, it has to have a subject. What is it about? So people across the state, as well as state representatives, either in the Senate or the House of Representatives, they know, what are we dealing with here? And so this bill, when it was presented, its subject was an act regarding regulation. That's all it said, an act regarding regulation. What does that mean? I mean, you can regulate literally anything. So an act regarding regulation, we argued that topic, that subject was so broad that it was rendered meaningless. Now, the bill, when it was introduced as an act regarding regulation, was adjusting the insurance code, the Illinois insurance code. It was very innocuous in nature, where the email address had to be provided by an insurance adjuster to people in a claim situation. And so for 345 days, that bill went through the House of Representatives, sat in the Senate as an act regarding regulation of insurance. And within 2 days before its passage, they gut out that whole provision regarding insurance and they replaced it with this weapons regulation. and the governor signed it 2 days later. So we argued to the judge that the single subject rule was violated on two fronts. One is that the subject of regulation is so broad that it can mean anything anybody wants it to mean, and that also insurance and gun regulation have nothing to do with each other. That's what we argued. And the governor and the attorney general argued, well, really the act is passed by the General Assembly only dealt with gun regulation, and that we stripped out everything to do with insurance. And I argued, well, yeah, so you just replaced it all completely and you took the insurance part out, but that doesn't satisfy the single subject rule. So that's what we argued as single subject, Adam. And the judge agreed with us. He says the word regulation is too broad. And in fact, you do compare the insurance regulation to the other. And for that reason, he agreed with us on that front.
And then also the three readings, the violation of the three readings coming back over to the House, right?
Yeah, the issue with the three readings rule has to do with is that once the three readings rule says in the Constitution that a bill has to be read 3 times in the House of Representatives on separate days and 3 times in the Senate on separate days. So a total of 6 days it's supposed to be in front of the General Assembly before it can ever be adopted. So the law also says that if someone amends a bill, like a gut and replace, and they change the nature of the bill to where it's no longer, the amendments are not germane to how it was introduced, that resets the three readings rule. So, for example, this bill that we're talking about right now, it went through the House of Representatives and got read on 3 separate occasions as an insurance modification. And then it went to the Senate. And in the Senate, they read it on 2 separate days as an insurance modification. And then between the second and the third reading, they gut it and they replace it with this weapons bill. The law says that resets the 3 readings requirement, which would require 3 readings then in the Senate, 3 readings in the House. But we don't do that. They allow it to just get 1 more reading in the Senate, and then they pass it. And it is a clear violation of the 3 readings rule. Traditionally, they have been able to get around that because up until now, the Illinois Supreme Court has said, yeah, we recognize that's a violation, but we're not going to intervene, and the legislature should do a better job of policing themselves. But what we have is we have Speaker Welch and we have President Harmon certifying that their compliance has happened, but they know that it hasn't. And this judge said, finally, the time for that has come to an end. We need to put an end to that. And so I'm finding that the 3 readings rule of the Constitution is being violated. And that's what he said. And the judge is saying what all of us know, and you men know better even than I, is that we're not following the way that legislation is supposed to be passed, which even though in the superminority, the Republicans can't change anything that's going to happen, you don't even get a chance to meaningfully participate in the legislative process. And this judge acknowledges that. So that's pretty much what he said. Adam,
yeah. And folks, that's really important because that could change the way we do business in the state of Illinois in the legislature. That could change gut and replace. That could change bills being read at 2 a.m. and dropped on us at 4 or 5 a.m. for a vote. So when I was hearing your arguments, Tom, on Wednesday on this, I was impressed with that. I'm very happy you brought that forward. But I'll let the other guys ask some questions get related to the due process, equal protection, and the irreparable harm.
And Scott, you guys addressed that same issue in the Safety Act in your lawsuit.
Well, we did. And I mean, again, it's a little bit different because of the way that what it impacts and the statute that we're dealing with. But it's something that's, ultimately it'll be decided by the Supreme Court once all the ours, because constitutional issue, went straight from the district court to the Supreme Court. So ultimately the decision will be there.
But I mean, part of your lawsuit had to do with this lack of the third reading subject matter, I mean, that was incorporated in your lawsuit. Is that still part of what you guys are arguing?
It is one of the issues that was raised at the trial court level. And if I remember correctly, it was one of the ones. I'd have to look, quite frankly, I haven't looked lately to see what it is that the judge, we allege like several sections or several ways that the act was violative of Supreme Court or of the Constitution. It is one of the things that then advanced based on those certain issues the judge found. And I believe the three subjects was one, or three readings was one, but I don't recall offhand. I'd have to look.
The judge in that case actually didn't uphold the three readings and the single subject. He deferred those away, and he relied upon the separation of powers argument in the Safety Act and said that it was a violation of separation of powers, which again, I agree with him. And again, the judge didn't foreclose the single. He found that single subject was satisfied, but the facts of that case were different than our case. So I didn't say the judge got that wrong in the Safety Act. As to the three readings rule, the judge in that case did find there was a violation of three readings, but he said that he was deferring to the legislature until the Supreme Court said otherwise. And again, I don't disagree with, I understand why the judge in the Safety Act case made that decision. But in this case, Judge Morrison said, this has gone on too long and it's gone on too far. I'm no longer going to defer. I'm going to find it's a violation. So even though the rulings were different in the Safety Act case and in this case, it's not that their reasoning was different. It was just Judge Morrison's no longer willing to defer to the legislature like the judge in the Safety Act case was. And again, I understand both positions. But he relied on separation of powers, Brad, or Dan, in the in that case.
We got some questions, Brad. You want to maybe hit Tom up with a couple of them?
Sure. So I'm looking here at the chat that's coming in, and also Tom, I'm just kind of, this is going to affect. So 860 plus people was on your suit, right? So this only really applies to them. You might explain that to folks because we saw that kind of play out. And I think State's Attorney Scott Reiter talked about being slightly different with the State's Attorney in the Safety Act. How does this apply? Let's just kind of go over that ground one more time, if you might, about how this applies to your plaintiffs and how this maybe is different than what happened in the Safety Act.
In the Safety Act, the ruling that was issued in the Safety Act case was a final ruling. It was like the case had come to an end and the judge had issued an order that resolved the whole case and found that the Safety Act was unconstitutional. When that final ruling was entered in that case, that immediately sends it on appeal to the Supreme Court of the state of Illinois. So the judge's order in that Safety Act case didn't directly apply statewide until the Illinois Supreme Court said, through a supervisory order, we're staying this law statewide. The Illinois Supreme Court had that power, and that's what they did in that case. In this case that we have now on the gun bill, it was an order from the local court here. That order of the local court only applies to the people in this case, and it's not a case that's now going directly to the Supreme Court because it's not a final order. It's only a temporary order that will eventually work its way down the road into a final order. And then it will make it to the Supreme Court, and the Supreme Court could do the same thing. Keep in mind, this case was only filed on Monday of this week, and we're at Friday. So the Safety Act case that Scott and these other state's attorneys were in, that case was around for several weeks, maybe a month, couple of months. And so it had more time to develop into a final ruling by the judge in Kankakee County. We're just more preliminary in this case, Brad. So the ruling only applies from this judge to these particular plaintiffs because it's not a ruling from the Illinois Supreme Court. It's a ruling from this local judge.
Right. So we can dive into that. I'm going to bring a question in here. I hope this shows from Tom. He says, how does this affect gun stores that were plaintiffs? Are they going to be able to sell the supposedly banned guns until the court rules further on this? What's your thoughts? Maybe dive into that just a touch more.
Yeah. Gun stores that were plaintiffs could have always sold these weapons, and we'll call them the banned guns, could have always sold them to people that were exempt from the law. And Adam was going there a while ago. We can come back to those exempt classes. But so they were always able to still sell them. They could only sell them to this small category of people. Well, now they are able to sell them not only to those small categories of people, they can sell them to the other 862 people that were listed in this case, because I had 4 gun stores in this case, 862 citizens. So the gun stores can now sell them to anybody that's allowed to buy them, which is exempt persons or those that are part of this lawsuit. A citizen that was not a part of this lawsuit and is not otherwise exempt is, again, the law says they can't buy them from anyone, whether it would be one of the plaintiff gun stores in this case or a different gun store.
Right. Dan, did you have a question or thought there?
Yes. So Tom,
Yes,
Monday morning, can I file a lawsuit here in Macon County asking for the same privilege?
Absolutely.
So should we encourage people then to file their own lawsuits asking to be added?
I encourage people to defend themselves any way they see fit. If people want to file a similar lawsuit to the ones that my clients filed and ask the court for the same relief, I've said it before, Dan, as you know, lawyers across the state, I'll send them the documents that I prepared and they can have them. It's nothing, I'm not trying to keep them. They can have them and they can go file those on behalf of all the people they want and ask for the same thing. Absolutely, sir.
So do we have to file as an individual, or can so I get an attorney here, can we file on behalf of all the citizens of Macon County, or do we have to name them individually?
Again, that's a procedural issue. You could certainly try to certify the class, is what you're talking about, is having 1 or 2 citizens ask the court to certify a class action for, the citizens of Macon County, the citizens of Illinois. A lawyer could try that. I made the decision as a lawyer to not try to certify the class beyond my clients because it's a bigger proposition, Dan. But certainly a lawyer could do that if they wanted to. Absolutely, no doubt about it.
Scott?
So, yep.
It looks like, Scott, you got something to add to that?
Well, just, and Tom, my primary concern is representing the county in any civil actions, but criminal prosecutions, that's where I come into all this. And I'll freely admit that with respect to these sorts of lawsuits that are really civil lawsuits in nature,
Right.
I don't know that I have a lot of ability to say with any accuracy, but my understanding here is that since we are in the 5th district here in Macon County now, basically there's a rule that applies full faith and comity. In other words, if another judge in this same district, the 5th district, has already ruled one way, we kind of have an advantage here since we're in the 5th district because there's already been a ruling in Effingham, which is the same district, that would influence any judges that this issue comes before in Macon County. Now, that may be different for the 4th district, like in Sangamon, or the 1st district up in Cook County. They don't necessarily have the same requirement to be bound by what another judge has already said. But I think anybody in our district, in the 5th district, that filing has kind of advantage now, thanks to Mr. DeVore, in terms of getting the same result. Is that right, Tom?
That's absolutely fair. The ruling that was made, and I know what you're saying, Scott, the ruling that was made from the judge in Effingham, it's not binding on any other judge in the 5th district, but there's certainly a lot of deference given to those opinions. So if we get a rule, if we go to the 5th, we are going to the 5th appellate district, and because they're going to file an appeal on this restraining order. And if the 5th appellate district upholds this restraining order that Mr. Morrison has entered, that becomes significantly influential for every other judge in the 5th appellate district. So,
absolutely,
to the extent that other attorneys want to file cases in other counties in the 5th appellate district, I would understand completely why they might want to do that. And I would encourage it, to be honest with you.
Tom, I see a question that somebody had there.
Yes, sir.
If somebody files in a particular county and they decide to go file for every individual in that county to have the TRO issued, and let's say the TRO issue is not granted, does that affect your case at all?
No, zero.
Okay. So we're not jeopardizing you.
Nah, zero, not jeopardizing it all, Dan.
And then also, Tom, could you talk a little bit more? I know some folks are curious about this on the federal level. Would a TRO from a federal judge could on the like Illinois State Rifle Association, some of these other lawsuits, could a TRO, would that happen? How does that work? And then if it does happen, does that apply to everybody in the state?
It could. It depends upon what they ask for. Federal courts are typically, more inclined to issue those broad-based types of rulings that can cover a state, or you've seen some of them in the past, they cover the whole nation sometimes. So the federal courts and their ability to issue and their desire or willingness to enter those very broad orders is different. So I've not read the State Rifle Association complaint in great detail. It's a little thin. I thought there were some arguments they could have made. But they, those federal issues or federal cases, they could seek a broad statewide injunction on these types of laws. And it's easier to do in those federal cases than it is state court cases.
Do you maybe see that argument? Do you see somebody making that argument for the injunction to be issued for statewide?
There's a couple of groups that are working on, and I've been asking them, please file your case soon in the federal court, that I haven't seen besides the state, not leave the State Rifle Association out. Dan's aware. He knows who I'm talking about. Yeah. They're working on them, and I was hopeful they would file them today. I haven't seen it, but they're coming, and Dan, maybe you'll speak to that. But they could ask for a statewide injunction. I've not seen their pleadings yet, but I'm hopeful that they might take a swing at that, because it's easier in the federal courts, Adam, than it is in the state court.
Yeah, I believe our working group is finally this weekend will finish their pleadings, and it's my understanding that we'll be in federal court on Tuesday.
Okay. Good.
And there's several cases that we're trying to piece out so that there's not just one great big case and we can go after all the different parts. And that's what's taken so long.
I expect to see cases on the magazines. It might be separate from the cases on the weapons. It might be separate from the cases on the registry. I mean, if I've already isolated how I'll argue these cases for my clients in the federal court. And I know who you're talking with, Dan. They're very intelligent people, so I'm assuming they'll do the same thing. Yeah,
and I know that we're ready to help you. If you get to a point where you want some help down in Effingham, I know our guys would be more than willing to pitch in, and if you've got questions or you need some backup.
Appreciate that. Yeah, those are intelligent people. I appreciate their work.
So we'll be there. I'm not sure exactly how many separate cases there will be, but you're right. I know the purchase, the magazines, the repair parts, that they're trying to put this puzzle together so that we can do that and be successful in all of them. I mean, and that's our goal. But I want to applaud you. I want to applaud you, Tom, for what you've done. I mean, this is a huge deal for all of us, especially in this court, in this circuit. And, I guess I need to make some phone calls.
Yeah, Tom, thanks for being, as just in the other suits, everything that went on with the governor's executive orders for the last 2 years, and now on this particular issue. Thank you for being the first one into the fight. And the
guy's a tyrant.
We applaud you.
It's that simple. He's a tyrant. I mean, he's a trust fund rich guy that obviously the only thing that excites him anymore is controlling people. And you know what? Yeah. If he was a more conservative person still doing what he's doing, he's still a tyrant. He's trying to control people's behavior. It cuts across the grain of everything this country's all about. And I don't have any use for him. So.
And Tom, could you talk about the yes. Oh yeah. Could you talk about the due process and equal protection portions of the argument?
Certainly. So as it relates to due process, there's a separate constitutional provision in our Constitution under Article 1, Section 2 that says that people, if your rights are going to be impacted, you have a right to due process, which means a right to be heard, a right to participate, and a right to notice. And you guys are familiar with that language from just doing what you do. And so separate and apart from the actual constitutional provisions of 3 readings and single subject is the right of due process. And so we argued in this case that you have a right of due process to expect that the legislature is going to follow its own rules of how it passes legislation. And so we said the mere fact that they completely ignore all of the rules of how they're supposed to pass legislation is an independent due process violation of the Constitution. The judge agreed with us and said, absolutely, it's a violation of due process, which again, and the reason that's important, Adam, is because the legislature, the Democrats have always relied upon the enrolled bill doctrine as a defense to the 3 readings rule. And so now I'm bringing an argument that says we'll leave the 3 readings rule, set it aside. I'm talking due process. And the fact that you violate 3 readings is a due process violation, because I have a right to due process, which means you're going to read this bill 3 times in each chamber of the legislature, and you don't do it. And so the judge agreed with us.
And
the issue of equal, go ahead, I'm sorry.
It's 3 consecutive, it's 3 days. It's not, you just can't stand up and read the bill, read the bill, read the bill.
Correct, sir. Yeah, 3 days. Yeah.
You have to read the bill 3 times over 3 days.
Yep, that's right. And so what they did is Dan, as you're aware, this bill made, and what the people of Illinois need to understand, and this was why this bill is as significant as it is in impacting the rights of people's firearms, is many of them up until now, gentlemen, probably didn't appreciate is they do this crap all the time.
Right.
And so with this bill, it was an insurance regulation for all 3 readings of the House. It was an insurance regulations for 2 of the 3 readings in the Senate. And then it became a gun bill, and they read it 1 time in the Senate, and that was it. And so we argued it's a due process violation, and the judge absolutely agreed with us. And so
Adam,
that was the 3rd thing.
Weren't you on that bill, Adam?
That was an insurance. Yes, that was a public adjuster insurance regulation to help consumers, and I was a co-sponsor on that bill. And that's why I was so happy that, Tom, you brought up the argument that you did, because Sunday at 3:00 I get a text saying they've done a gut and replace on a bill that you co-sponsored, and we can't take you off of it until it comes back over to the House. So as everybody's voting on it, on an insurance regulation that gets gut and replaced into a gun bill, they see my name on it. So yes, my office did get calls on that, and I did not support, nor will ever support, an anti-gun bill. So I know that Darren Bailey made a comment to me that even though my good friend Adam Niemerg's on this bill, I'm still have to vote no. So he had a good sense of humor about it. But that's the games they play, folks. Those are the Democrats. They know I'm a conservative Republican. They know that I'm very outspoken. I hit my speak button all the time. I hit my no button a lot more, and they like to come after us. So when you were making the argument, Tom, Wednesday about the single issue.
I think I mentioned you, didn't I?
You did. My radar went up right away, because these are the things that we've got to stop doing in Springfield. This is the major problems. The Safety Act passed 3, 4, 5 in the morning. We had a budget that comes through at 11 o'clock, 11:50 at night. We voted on 11:55. Last session, we pulled a complete all-nighter, voted on some very bad bills at 6:30 in the morning after being there for 16 hours. And then on this, it was Sunday at 3:00. In the Senate. And the Friday before, they ran a gun bill and abortion bill at about 10 o'clock or midnight also. So they do all this while you're sleeping. So for Tom, do you bring these arguments, and for a judge to agree with you on a TRO for these very issues that affect how the legislature functions, in addition to our rights as Second Amendment rights, is really big. So thank you. But yeah, folks, the games they play. So
I thought that would be an interesting subject to get into.
Roger made a comment. It's not games. It's violation of constitutional law. Yes,
it is, and it's not the rules that they're violating, Tom. It's the Constitution.
Yeah, I mean it's the procedural requirements of the Constitution. It's absolutely what it is.
Yeah,
they're not rules. They're constitutional mandates. The governor likes to talk about mandates all the time.
Right.
Those are the mandates that matter.
Yeah. I mean,
and wouldn't you guys agree? I mean, that's why the pushback on the Safety Act was so important. That's why this victory today on this action is really important, to try to expose the games or the violations to the Constitution that the majority party's doing. It seemed to me that that's why this stuff is really, really important, to finally shine the light on the darkness that's going on up there.
And I told him, Brad, I said, because I had a few interviews today, a few dozen, and I said, if they want to pass a law that does what it's trying to do, we'll go ahead and pass it, and we'll go argue about it in the federal courts on Second Amendment process. That's fine. But I'm like, if you want to pass this law, pass it the way that you're supposed to pass it. Present a bill, have somebody sponsor it, read it on this day, read it on the next day, and go through the process and let the people see what's going on. And then we'll deal with it at the end. But, this lawyer, and I know Mr. Kincaid, that's the lawyer for the Attorney General's office. He's a decent enough guy. But he was arguing, Adam, you listened to him, you don't have the rights to complain about any of that. You just have a right to try to defend yourself against the law after the fact. And I'm like, that's nonsense. I mean, we have a right to defend that. We can expect that you follow the legislative process the way that it's supposed to happen. And if we don't like the outcome, as long as you follow the way that the legislature is supposed to work, then we can go argue about it. But and the judge pointed out
it was a weak argument. They're very weak.
What's that?
Yes, you're right. There was a very weak argument, and there were some chuckles from the folks in the courtroom as they were making the argument. It was really weak.
Was that you and Darren in the back chuckling?
No, we were quiet.
It was Adam. Probably it was Adam. Okay, it was Blaine. He's not here to defend it.
Okay.
Yeah. Representative Wilhauer.
You want me to talk about equal protection now?
Yes, please.
Okay, so the last argument we made was equal protection. The Illinois Constitution, Article 1, Section 2, says that people are entitled to equal protection under the law, which means if a law is passed and assume everything else is okay, it treats people that are similarly situated similarly. It's pretty common sense. You learn that in 8th grade, constitution. So this law that's trying to regulate firearms and says that you can't buy any more of these types of weapons. You have to register them. You can only have them in certain places, etc. It carves out 7 categories of people based on their occupation. You can own all of them you want. Current retired law enforcement, prison guards, jailers, county jailers, wardens, superintendents. Think about a warden. It's a political appointment. Security guys, things of that nature, or gals. And those whole categories can buy all they want. So if you're a jailer at the county jail in Effingham County, you can go buy all the AR-15s you want, hundreds of them. You can buy 50 cal, as many as you want. 30-round clips, go buy 1,000. That's fine. Buy all of them you want to because you're a jailer at the county jail. If you're a retired cop. Now, here's an interesting point. If you're a retired Navy SEAL, you spent 20 years as a Navy SEAL, one of the most fierce fighting warriors on the planet. While you were in the military, you were okay. But once you retired, no, you can't do it anymore. You're not exempt. But the retired city cop is exempt. It's ridiculous. It doesn't make any sense. And they tried to argue at this hearing that it was because of their training of these exempt categories. It's because of their training. And the judge didn't agree with that, and I argued against it. It's like, what does training have to do with anything? What about the people that have adequate training that don't work in these professions? Why can't they have their weapons? They didn't have a good answer because this was never about training, gentlemen. This was about a very politically connected group of occupations that have very powerful lobbies that were able to get their members carved out. That's what it was all about. You guys know that as well as I do. And they had to make up some reason why they were exempting all of these groups out, and the judge didn't buy it. So the judge found that this was a violation of equal protection, which that of these 4 arguments that we're making, that I'm passionate about all of them, that's one of them I'm most passionate about, because the individual right to bear arms is the same for all of us. It doesn't matter where the heck we work. Our employment is not indicative of our individual rights to bear arms. And the judge saw right through their argument, and he found that we've raised a fair proposition that equal protection is being violated, Adam.
In fact, the Second Amendment is about those that aren't.
Yeah, exactly. Training. What's the Second Amendment got to do with training? Nothing.
Or being a law enforcement.
And again, they tried to bootstrap law enforcement to their training. It's like, oh, they're trained so they can own all of them they want. And I'm looking at them going, so I'm a cop, retired cop, not a retired law enforcement or a retired military. They don't qualify, Dan.
Thank you.
Retired military, retired law enforcement. No disrespect to law enforcement. Go buy 1,000 of them. Buy all of them you want. It's okay. It doesn't even survive a rational argument. It doesn't make any sense. And the judge agreed with us.
Yeah.
I
got 22 years. I can't tell you how many 50 cal rounds we put down range
But since
How
you're
much time?
retired, Mr. Caucus, you are not exempt.
Exactly.
Yeah.
You
You
would
are
thought
not
they-
adequately trained.
You would have thought they would have exempt members of the General Assembly. They
Exempt
wanted-
lawyers. Why don't we exempt lawyers?
Oh, no, we can't trust any of you.
Dad,
Somehow I think that Governor wants to make sure that members of the General Assembly don't have access to firearms. Just a guess.
Well, didn't they at one time proffer a bill that was going to make us able to arrest people?
They did.
yeah, you're going to be able to carry a weapon at that one
Yeah.
time, right?
I get out my straw. You're under arrest.
Hey guys, we probably ought to bring this to a close. We could probably talk till another hour or two. I guess I appreciate everybody jumping on late night. Dan, thank you for the idea to try to get us all together tonight. I think this has been good stuff. We've had great participation from our team. Lots of comments there tonight. I just want to encourage our viewers and listeners always to like and share, subscribe and follow our content. Tune back in Tuesday night. This is going to change by the hour, or by the day over the next several days. And so I'm not sure what we'll do Tuesday night on our live stream, but I'm sure it's going to be more of exciting details of either what's happening in Effingham or what's to come, maybe with the federal cases, whatever the case might be. Chris, you've been kind of quiet. Let's kind of close this out. Chris, any closing
let Chris
comments?
close it out. Give
Yeah,
us a good
what's any
sermon,
closing-
Mr.
yeah.
Miller.
And I've been thoroughly enjoying this and been entertained as I lined them up and let them go. But, I think that we're seeing in real time the true character of the radical extreme Democrat Party in this state and the tyrant that leads them, J.B. Pritzker. They look at the Constitution as an inconvenient piece of paper, but thank God for the rule of law and lawyers like Tom and others that are standing in the gap for us and making sure they do the right thing the right way, because the law is important. And thank you very much for all your time this evening. Has been great.
Adam, I know you had a busy evening. You got a young family. You're a stand-up guy on the General Assembly floor. You're pleading the case for us folks back home. And what's your thoughts here as we close out and look forward to next week?
Well, the kids have been quiet. They're upstairs, so I think they're doing okay. But Tom, thanks for being here. Scott, thanks for your input as well. Folks, I have to say that we're gonna keep fighting for our Second Amendment rights. We discussed the federal issues, we discussed the state issues, we discussed what this means for you, the people of the state of Illinois, what to look forward in the future, and what actions for you to take. So we'll keep you informed as always. Thanks, Tom. I know this was a very busy day for you, and you've been here with us for about 45 minutes to an hour. So thanks again for being with us, and thanks for all you do.
My pleasure.
And Dan Caucus from Decatur. I know you were traveling a little bit. We're all kind of on the road. It's a busy time of the year as we prepare to get bills drafted and filed, and just a lot going on. Dan, thanks for putting this all together this evening. What's your thoughts here? Thank you for inviting your state's attorney also.
Well, it's great conversation. I think very, very informative. Scott, thank you for giving up your Saturday night.
Dan, it's not Saturday.
Friday.
No, it's Friday night.
I love it.
It is Friday.
Well, the days are running together. We might be back here on Saturday night, so we might be. Yeah,
we'll be good.
Yeah.
There's a couple of things. We're working with the Illinois State Police, trying to get them to clarify what this bill says and how they're going to treat it. I've posed a couple of questions to them about people that prior to the signing of this bill had pawned a firearm that's on the list, and now they can't get it back. I've queried them about a person who consigned a firearm that's on this list with an FFL, and now they can't get it back. Technically, the state police are correct because that's a transfer in, and then the FFL would have to do a transfer out, and those transfers are now illegal. My point is that this is a taking of a person's property. We have no one, that person that pawned that, that rifle or pistol or put it into an FFL for consignment to sell. Yes, that had to go into their book, but they never intended to give up their property. And now the state of Illinois has taken their property without due process. And I look forward to having that conversation with the director. I think that, this is technically legal under this new law that will hopefully get thrown out as unconstitutional. But in the meantime, there's no mechanism. The Illinois State Police could easily make exceptions. They could easily say, if that weapon was on the books prior to the bill being signed into law, that person still technically owns that firearm and they ought to be able to get it back. So we'll see how successful that is. But I think that's one of the most egregious parts of this bill.
Yeah.
One of many.
Yeah,
So we'll continue to fight for you folks. We'll continue to take your questions to the authorities. And I look forward to Tuesday, Tom. We're gearing up for a big fight in federal court. And I don't know.
I look forward to do it too.
Yeah, I don't know where you go next with Effingham County. But I know what I'm going to be doing this weekend in Macon County.
I think I got a feeling there, Mr. Caucus.
Thank you, sir.
Yes, sir.
Scott Reiter, any closing comments? Thank you for taking time out of your Friday evening to jump on here with us on short order. Any thoughts that you might have?
Oh, it's my pleasure. You know, Dan's talking about, he and I both know, everything comes down to local in terms of what you do and what you know. And there's a firearm owner or firearm dealership owner here in Macon County who takes weapons on consignment from people who give them to him to sell for them. And this has created a real roadblock because officially those weapons have to be transferred to him in name to be able to sell them. But they're still the property of the people that gave them to him, say, hey, sell these for us. And now they're stuck. Those people don't get the property that they gave on consignment. It's kind of similar to an eminent domain argument where the government is taking property without just compensation. It's just a real mess what has occurred, especially again, here we are just like the Public Safety Act, the Pretrial Fairness Act, late night, it gets passed in the late hours of a lame duck session without any true debate, around any true consideration, or without talking to the people that have a stake or an interest in it. And that's the real injustice, is it's not a representation of the entirety of the people of the state of Illinois. It's a representation of a small group that has current power.
Yeah, exactly. And I think this presents another problem for hundreds of pawn dealers across our nation that any given time, I'm of the understanding that pawn dealers across this nation could have 10, 11 million firearms in their possession that have been pawned, or maybe they're in some level of safe storage. So it presents a similar issue with those folks. So it puts a lot of folks in a bad way, but in the majority party's rush to get something done, some of these things were not thought through. Yeah.
Yes, sir.
Attorney Tom DeVore, closing thoughts from you here on this busy week and great afternoon, great evening of a positive result for gun owners.
My closing thoughts is that, long term, I'm looking for us to find a solution to where legislature works the way that it's supposed to work. That's all I've been trying to do the last 3 years, gentlemen, is not, trying to control the outcome. I mean, I have my personal beliefs about how things should happen, like all of you. But at a minimum, our government has to work the way that it was intended to work, and it has to function procedurally how it's supposed to. And if it does, we may not always get the outcome that we like, but at least it works the way that it's supposed to work, and people are aware. So this is another example of short-circuiting the way that the legislature is supposed to work.
Right.
It's a workaround. The governor and his executive authority is abusing people's rights, and we have to bring awareness to that and for people to appreciate what's going on. And I've tried to do my best to explain to people that may be okay with the result of this law and say, look, just because you're okay with the outcome doesn't mean you should fail to consider the abuses that are going on. Because if the time comes to where people are in charge that you don't agree with, you're going to be the short end of that stick, and you won't like it. So if we can raise that awareness and use this law, overturn it and get rid of it, but to bring awareness to these abuses of procedure, then it'll be a good day.
Excellent points. Gentlemen, with that, let's sign off. Wish everybody a great weekend and hope to see you back Tuesday.
Thank
for
you,
sure,
gentlemen.
if not sooner. Thank you.
Let me know if I can help, Dan.